Florida's stand your ground laws didn't stop my client from being arrested, but it did stop him from being convicted. He and his co-defendant friend were at a house drinking with the homeowner. A scuffle broke out and the homeowner armed himself with a knife. My client and his co-defendant friend tackled the homeowner down, disarmed him, and then left the residence in their vehicle. The wife, she stepped out of the back room hearing the commotion. She called 911 and gave a bolo to the police describing my client's vehicle. While the police were responding to the scene, they intercepted my client's vehicle not too far away from the house, pulled him over, and arrested both of them for battery. In this video, we're going to discuss how we use Florida's stand your ground laws to get this case dismissed. Let's turn to the courtroom audio and listen to the judge explain the situation.
Alleged victim in this case testified that he invited Mr. and Mr. to the house, and they were invitees. They were allowed to be there. They had a lawful reason for being there, and that they were all consuming what the court would consider to be an excessive amount of Johnny Walker Black in a 2-hour period. Then I have Mr. First, and his testimony was that he was sucker punched. However, gave no statements to law enforcement besides, I want to press charges. A review of the photographs show I don't see any punches being thrown. I say someone on top of someone. I don't see Mr. holding someone down while punches are being thrown. And notably, the alleged victim's wife, who allegedly witnessed the event, is not here to testify.
In this video, we're discussing Florida's stand your ground laws through the lens of my client's case. The prosecutor on the case doesn't believe that stand your ground should apply to my client or the co-defendant. We're going to use this case to demonstrate how stand your ground laws work in a real-world situation and how we use the law to force the prosecutor to dismiss this case. In law school, they call this type of education a case study. We're taking a look at the legally significant facts of a situation and we're applying the appropriate law to find out what the outcome will be. In this particular case, we're looking at Florida State Statutes 776.012, which is the self-defense provisions of justifiable use of force. As my law school professor, Colonel John Duncan, used to say, welcome to the law. None of the videos on this channel constitute legal advice. This is educational content designed to make solid men stronger in their knowledge of the law. Legal advice is different. Each case has unique facts and circumstances, and each person has collateral consequences in their life related to work, family, and other responsibilities that make it impractical to give legal advice at scale. This is educational content. Treat it as such. Florida's stand your ground laws are actually a body of laws that, when read together, provide a fair amount of protection to people who use lawful force. For the purposes of learning, let's organize these laws by the functions they perform. The actual stand your ground laws, the exceptions to stand your ground, case law, which is a written court opinion of the court's interpretation of the statutory law, and legal protections, which give stand your ground laws its teeth. We'll be talking about those in a few minutes. I've already done a video on the immunity statute based upon the facts of this particular case. I'll put a link to that on the end screen of this video. Pro tip, when you're reading, stand your ground is often referred to as SYG, Sierra Yankee Golf. Since we're talking about justified use of force, we're going to turn to Chapter 776 of the Florida State Statutes. Specifically, we're going to be looking at 776.012. There's 3 different stand your ground statutes. This one in particular addresses defense of person. In order for my client to be afforded the legal protections of Florida's stand your ground laws, he's going to have to comply with this statute. Let's read that now. Florida State Statute 776.012, defense of person, subsection A. A person is justified in using or threatening to use force, except deadly force, against another when and to the extent that the person reasonably believes that such conduct is necessary to defend himself, herself, or another against the other's imminent use of unlawful force. A person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use such force. A person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another, or to prevent an imminent commission of a forcible felony. A person who uses or threatens to use deadly force in accordance with this subsection does not have the duty to retreat and has the right to stand his or her ground if the person is using or threatening to use deadly force and is not engaged in a criminal activity and is in a place where he or she has a right to be. We've read the law, now let's apply it to the facts. Let's go to the courtroom and have the judge bring us up to speed on how these guys met.
Common sense checks itself at the door. I've got to go by the facts that are presented and the evidence that was presented here in this hearing. And the evidence I have in this hearing is that the alleged victim met two strangers in a parking lot at Walmart, decided it was a good idea to go buy a half gallon of Johnny Walker Black, have a couple drinks in the car, then invite these two strangers, who he testified to, back to his home to continue to drink for another hour and a half or 2 hours to finish 3/4 of about half gallon of Johnny Walker Black, right? And then his testimony is that he was sucker punched by Mr. And then he went to go to the kitchen, which was about 5 feet away, to get a knife. And then that's when the scuffle ensued, and that's when the wife showed up of the alleged victim. Mr. testimony is that all that happened with the Walmart and the drinking and then going back to the house until such time as the alleged victim got up and sucker punched Mr. grabbed the knife, then the scuffle ensued. So the issue is who threw the first punch. Right. But Mr. Lauder's argument is his argument. The only thing I have is Mr. R.'s testimony and the alleged victim's testimony.
Everyone agrees on all the facts leading up to the first punch. That's the question. Who threw the first punch? The co-defendant or the homeowner? But no matter what, it's not a question that my client didn't throw the first punch. Nobody's accusing that. The only time my client got involved was after the homeowner brandished the knife. So no matter how it works out for the co-defendant, my client is clear here. Purely innocent. Remember I said the prosecutor didn't believe that stand your ground laws should apply? His position is that the invitation, the license to be inside the house, was revoked. In the legal world, you need to think about license as a concert ticket or a football game ticket. It's something that allows you access. It can be yanked from you, just like your driver's license. So the prosecutor's position is that the license to be inside the house was revoked upon the first punch. So any battery thereafter can't be stand your ground because they're not there lawfully. I think we need to look at the statute again, but we'll leave that for another day. One of the complexities with understanding Florida's stand your ground laws is that the stand your ground law itself doesn't provide a procedural framework for which you can get the case dismissed. To understand how to get the case dismissed, we got to look to another statute. In this case, my client's being prosecuted criminally. Therefore, we're seeking immunity from criminal prosecution under Florida State Statute 776.032. If the judge agrees with us, the state will be forced to drop the charges. If the judge agrees with the state, the case will continue on to a jury trial at a future date. At that point in time, we'll still be able to present our stand your ground defense, but we'll be presenting it to a jury instead of to the judge. When all was said and done, the judge agreed with us and the state was forced to drop the charges. Stand your ground law is complex. I created another video discussing the legal protections and how they apply to this case. If you'd like to see a video breaking down the immunity statute 776.032, click the link right here. If we haven't met yet, my name's Jeff Lauder. I'm an attorney based out of Orlando, Florida. If you need an attorney in Florida, I'd appreciate the opportunity to earn your work. Give my office a call. Hit it hard.